And we're going to start with the first part, presented by Dr. Luc Gonin, who's a lecturer in public law at the University of Neuchâtel in Switzerland, and a senior researcher with the postdoctorate in human rights. Dr. Gonin is going to present a paper called Where Philosophy Meets the Idea of Democracy and Human Rights, the Complex Equation of the Swiss Political System and its International Relevance. Please.
Thank you. So, good afternoon to everyone, and as said, I would like to make a small presentation today. And in my presentation, I would like to demonstrate the importance links between the idea of democracy, human rights, and philosophy. I will try to prove those links by using the example of the Swiss political system. Indeed, collisions of human rights or between human rights and democracy are particularly important and frequent in that country due to its semi-direct democracy. Quickly, in regards to the structure of my presentation, I'll first present some of the main features of the Swiss political system. I'll then concisely depict the international and national protection of human rights in that country. Afterwards, I will highlight one major consequence of the interactions between democracy and human rights in the Swiss political system. I will also present the solution proposed by the actual constitution, and afterwards I will try to answer the question if new limits should be created for the Swiss constitutional system. Before concluding, I'll also try to demonstrate why the Swiss equation is relevant on an international level. As you probably know, Switzerland is a semi-direct democracy which has specific features compared to a classical representative model. Not only has the Swiss population the possibility to give its opinion about major legislative and constitutional modification, but it can also propose a complete or partial revision of its constitution. In practice, partial revisions of the constitution is the option which is the most used, and as you can see, since 1893, the Swiss population voted more than 180 times on such revisions. Until now, 19 initiatives have been accepted by the Swiss people and the canton, which means the federal entities of that country. Thus, semi-direct democracy is not only a nice and useless concept, but it has a concrete and deep impact on the Swiss political system year after year. Therefore, the Swiss political system has endorsed the words of Rousseau when he argued that, and I quote, "The power to make laws belongs to the people and can only belong to them." In other words, in Switzerland the people and the federal entities are truly sovereign in the sense put forward by Baudin, the French thinker, because they have the last word regarding the legal and constitutional norms. Just as a reminder, Baudin stated, and I quote again, that the power to give and break the law is the only feature of sovereignty. Now, because we talked about democracy, we have also to talk about international and national protections of human rights. There are three main levels of protection of freedoms and liberties, or human rights in Switzerland. The first one is the cantonal one, which means the subnational level. And since 1999, there's also an important catalogue of freedoms and liberties in the federal constitution. In addition to those two national sources of protection, the population of Switzerland is also able to invoke provisions rooted in international law. Ladies and gentlemen, as you probably know, Switzerland is a member of the Council of Europe and recognizes, therefore, the jurisdiction of the European Court of Human Rights. I don't know what that is, that's not me. So, what we can say about the protection of human rights is that Switzerland refuses to be a Leviathan state, which has its origins in the political thought of Hobbes. On the contrary, this country was deeply imbued with the ideas of freedom and equality as developed in France and the United States in the late 18th century. It is also not possible to deny the impact of the Judeo-Christian conception of law on the Swiss state and on its system of protection of human rights. In this regard, I just would like to quote Albert Cohen, the famous French writer of the 20th century, who said that Judaism and Christianity shared the same desire to transform the natural man into what he calls a human man. In my view, human rights clearly promote such a transformation. Therefore, we can go to major consequences of the strength of the ideas of democracy and human rights in Switzerland. One major consequence is that they might collide in a particularly strong way. Thus, should it be possible to be concrete, should it be possible for the Swiss population and the canton to vote on a constitutional ban of minarets in the name of democracy? Or should such a constitutional amendment be forbidden in the name of human rights? Furthermore, may a popular initiative seek to introduce in the Constitution the automatic deportation of some categories of foreign criminals? Or should such an initiative be invalidated because it is contrary to the principle of non-refoulement? As a reminder, this principle prohibits the expulsion of aliens to countries where they risk severe persecution. If those questions might seem quite theoretical, they are not at all. A majority of Swiss citizens and cantons accepted a constitutional modification prohibiting the construction of new minarets in 2009, and 1 year later, they also accepted the principle of automatic expulsion of foreign criminals who had committed serious crimes. Thereby, I affirm that the Swiss political system is a complex equation. Switzerland must sometimes decide between the respect of democracy or compliance with the fundamental rights. Let's examine the actual solution proposed by the Swiss Constitution to solve this complex equation. In the Constitution, there are three conditions which are provided or which are foreseen. If a constitutional amendment wants to be declared valid by the Parliament, those are the three conditions. First, the initiative has to comply with the requirement of unity of form. The condition of unity of subject matter represent the second condition. These two conditions do not have a major impact on the relations between human rights and democracy. That's why I will also not elaborate here on their exact content. But there is a third one, and this third condition has closer ties with our equation. A popular initiative, according to the Constitution, cannot infringe mandatory provisions of international law. The main problem with this requirement is that the Constitution does not explicitly state what mandatory provisions of international law are exactly. For instance, does this expression only include the prohibition of genocide, slavery, and torture? Or does it include also the general principle of humanitarian law? In addition, does it also comprise some human rights, or all of them? Accordingly, as you can see, the exact definition of this third condition is fundamental to try to solve our equation. About that notion of mandatory provisions, we can say the following. So far, the Swiss Parliament has favored a quite restrictive approach to the concept of mandatory provisions. Thus, when it had to decide on the constitutionality of the initiative banning minarets, it did not consider that it violated those provisions. It reached a similar conclusion when it had to determine the constitutional validity of popular initiative for the automatic expulsion of foreign criminals. Therefore, due to the relatively favorable approach to democracy of the Swiss parliaments, risks of conflict between democracy and human rights are rather important in Switzerland. The position of the legislative power is therefore, on a philosophical level, influenced by Rousseau again, which emphasized the importance of democracy. As an intermediate conclusion, we can say the following. The Swiss political system provides for restrictions on direct democracy in the constitution. However, they are not sufficient to exclude any risk of collisions with human rights. On the contrary, recent constitutional practice highlights the dangers of concrete collisions. Therefore, one main question arises. Should new limits be introduced in the Swiss political system? This interrogation is actually way more political and philosophical than strictly legal, as I will try to demonstrate in the following section. Many options have been proposed in the last years to reduce the possibility of conflicts between human rights and democracy in Switzerland. One major proposition was to forbid any popular attempt to modify the constitution which violates internationally protected human rights. Undoubtedly, such a proposal would solve the complex equation that Switzerland faces. Nevertheless, in my opinion, this proposal raises various and important problems. First, ladies and gentlemen, who would decide that an initiative brought forth by the people violates human rights? Would it be the parliament or the judicial power? If the parliament is in charge, one might wonder if that organ has enough legal knowledge to decide such difficult questions. Nevertheless, this institution has an important democratic legitimacy. If it is the judicial power, one might ask why a happy few decide instead of a majority of citizens or instead of their representatives. Indeed, judicial decisions on human rights are rather political than legal sometimes. For example, abortion can be considered as constitutional by a tribunal, affirming that freedom of choice of a woman must prevail, while another tribunal asserts that the right to live of every fetus must be legally protected. That's just one example. Thus, a general invalidation power of popular initiatives by the judicial power seems to be, at least, questionable. Indeed, giving such a power to a constitutional tribunal is, primarily, a philosophical and political decision, and not mainly, as you will have understood, a legal technical decision. In fact, to grant this prerogative to court raises the philosophical question of the distribution of power within the states and the related issue of supreme authority within a nation. Second, because there is also another question. One might question if it is wise to greatly limit democracy for quite undefined rights, such as human rights. History has shown that limitation of democracy in general did not help the common good, far from it. Concentration of power represents, indeed, one of the main problems for the rule of law, and modern political powers constantly tried to create systems of checks and balances. Third, it must also be said that thanks to the adaptability of the Swiss constitutional system, this country has experienced a very long period of civil peace. Needless to say that this statement cannot be made for all European states, unfortunately. Therefore, in my view, the weakening of this constitutional adaptability is problematic because it may lead, on the long term, to less civilized form of violence. Hence, the prohibition of any popular attempt to modify the constitution which violates internationally protected human rights is not an optimal solution to reduce, in the long term, the tension which exists between human rights and democracy. In my opinion, another solution is more promising. I propose to only ban constitutional amendments which are not compatible with the essence of human rights. Indeed, no type of democracy might want to attack the very heart of those rights. In fact, such an assault would be contrary to the spirit itself of democracy, a political regime that unquestionably puts the individual at the center. Certainly, such a solution does not solve all problems. However, it prevents democracy from degenerating into a despicable political system. The proposed solution would also have the benefit of being quite proportionate, defending both democracy and human rights. Before concluding, I just would like to say a few words about the international relevance of the Swiss equation. In my opinion, the difficulties faced today by Switzerland do also concern other countries in the next decades. Indeed, if the problematic of the interactions between democracy and freedom and liberties is quite acute in a direct democracy, it is not completely absent from representative democracies. For instance, just 2 or 3 examples. Do national parliaments have the right to prohibit the wearing of burqas in public space, although there is a regional system of protection of human rights? And may an elected Congress impose the presence of a crucifix in every school in a Catholic country? Are these measures consistent with the freedom of religion? Furthermore, what are the exact limits of freedom of expression? May, for example, a national law prohibit criticism against the royal family? This question underscores the fact that the problems faced by Switzerland today concern the rest of Europe too. Actually, in my opinion, they concern all democratic countries. Thus, Switzerland is maybe for once ahead of its time, underlining future challenges for other states. As a conclusion, this presentation shows that what seemed to be a pure juridical or legal question is strongly linked to philosophy in general and political philosophy in particular. Indeed, the solution adopted by states to solve this equation relies heavily on philosophical convictions. The issue that has been discussed requires each and every one to reflect on the exact role of the individual in the political order. It also compels every citizen to think about the exact role of political power. Must it only ensure civil peace in general, or should it take extensive measures in favor of minorities? It also raises another question, the issue of who should have the last word in the democratic order. Is it the people, the parliament, or the judges? It is no exaggeration to argue that the chosen topic is not limited to human rights, and that it is also not only about democracy. In reality, and as I have attempted to demonstrate it, it primarily concerns political philosophy as such and the general theory of law. Thank you very much for your attention.
Thank you, Luc, for such a structured and constructive presentation. We now see that direct democracy is possible and it exists, and we're gonna go to the second part, more dramatic, of the indirect democracy reality nowadays. Do you have the presentation?
Mm-hmm.
Okay.
But I had a question for you.
Okay, great too.
You talked about the essence of the human rights. What do you understand by the essence of human rights?
So the question is about essence of human rights, like
Because in my opinion it's quite an abstract
concept.
notion, yes, and who has the power to define the essence of the human rights? Because it's not very clear to me.
Yeah. So the question of the essence of human rights as a limit to democracy is quite a difficult one. And first, like the definition of essence or core of the human rights is really difficult because there is no generally agreed definition on it.
Exactly.
And what we have seen in Switzerland is that it's rather like the tribunals, which are like developing some theories about the essence or the core of human rights. But I think we could talk about that too, because it is true that it is a really complex and delicate question.